All right. Well, good afternoon, everyone. Thank you very much for coming to today's talk. My name is Avidan Cover. I'm the director of the Institute for Global Security Law and Policy, and I'm very gratified today to introduce to you a speaker who's going to talk about a very important and timely topic, one that touches on a variety of very powerful emotions and raises important issues of law. Sexual abuse is an epidemic problem, both in our society at large and in our armed forces. In 2012, there were reportedly 26,000 instances of unwanted sexual contact in the United States military. The military has been heavily scrutinized for its inability to resolve the persistent problems of sexual assault within its ranks. And some have pointed to the very structure of its legal system, the Uniform Code of Military Justice, as the root problem. Under the UCMJ, commanding officers, not prosecutors, decide whether to prosecute cases of alleged sexual assault. And just last month, the Senate failed to pass a bill to overcome a filibuster that would have reversed that set of affairs, removing the commander's authority to decide whether to prosecute and instead granting that authority to independent military judge advocates general. As I said, there are of course differing and passionate views on the subject. The safety of soldiers, concerns of due process, military order, they're all at issue here. And to help us navigate these difficult, emotional, and important concerns, we are very fortunate to have a graduate of Case Western Law School. We have here today Lieutenant Colonel Jeremy S. Webber, who is an active duty Air Force judge advocate and now serves as an appellate military judge on the Air Force Court of Criminal Appeals. In this capacity, he rules on appeals from Air Force courts-martial worldwide, when the approved punishments may include death, confinement for 1 year or more, or a punitive discharge. And these decisions are reviewable only by the United States Court of Appeals for the Armed Forces and the United States Supreme Court. Prior to his current assignment, Lieutenant Colonel Webber served as the staff judge advocate at Vandenberg Air Force Base, California, where he led a legal office of more than 20 officers, enlisted members, and civilian employees providing legal services to more than 7,400 personnel. He's held a variety of very important jobs within the military and in the Judges Advocate General positions. He's a graduate of Bowling Green, a journalism major from the class of '93, and as I mentioned, a graduate of this law school back in 1996. I'm very pleased to introduce Lieutenant Colonel Jeremy Webber.
Well, thank you very much. I'm honored to be back here. Thank you for Professor Cover and all the members of the law school who made it possible for me to come up from DC today to speak with you. I'm also happy to have my family here. My parents, Dick and Lynn Webber, are here. They live in Ohio, about an hour south of here, as well as my kids who came up with me from DC yesterday, Joel and Lacey. Joel is a future lawyer. I know that's because of the degree to which he argues with me. I never knew that there could be a better advocate until I met my son. They're 14 or almost 14 and 11 years old, so they have permission to be on their electronic devices while I'm speaking because they hear me talk all the time. The rest of you have no such excuse. I'm honored to be back here. This is the first time that I've been back to this school since 1996. And I waited that long because I wanted everybody who knew me back then to have moved on. So I finally, after 18 years, I have a clean slate and I can come back. So it's a real treat for me. I want to talk to you about an important issue, namely military justice and sexual assault. Specifically, whether the military justice system really dispenses justice in cases of sexual assault. A couple points up front. First, I'm absolutely open to questions. I have some remarks prepared. But if I do nothing but answer your questions for our time together today, then this is a productive use of our time from my perspective. So please raise your hand, ask questions at any point. You're not interrupting at all. Second, while I wear the uniform today, and I am an active duty judge advocate for the Air Force, I'm speaking today in my personal capacity. My views today don't necessarily represent those of the Air Force, the Department of Defense, the Judge Advocate General's Corps, my fellow judges, my fellow judge advocates, or anyone else other than me. We have a concept in the military where we call academic freedom, where we're in an academic environment. It's a non-attribution policy. We can all speak freely. If we need to criticize the institution for which we work, we do so. And I'd ask that you respect that here today and understand that I am speaking for myself. I also realize that this is a sensitive and emotional topic for some people, particularly if you've had or know somebody who's had experiences or been a victim of sexual assault. And I'm absolutely sensitive to that, and I'll try to respect your views, as I hope you try to respect mine. Last introductory point is that I'm not here to recruit today. So if you think that somehow by agreeing to attend this seminar you've signed up for a 4-year enlistment or something like that, and put your mind at ease right now. It's only a 2-year enlistment. But I am happy to talk to people individually afterward. I do have some promotional materials outside on the table, so if you want to grab a free pen or highlighter or a business card with our contact information, please feel free to do so. Sexual assault, of course, has gotten a great deal of attention, particularly in regards to the military. There's been heavy criticism of the military for its perceived inability to resolve the problem of sexual assault within its ranks. Military leaders, I can tell you, are listening. The problem of sexual assault in the military has a very high priority. In fact, our highest leaders within the military, the chairman of the Joint Chiefs of Staff, the chiefs of staff of the respective services, have all called it their number one priority to deal with this. This issue has more attention at the 3- and 4-star and senior civilian level in the military than any issue I can remember in my 18 years of service. To the point where there are people who question whether our ability to fight and win wars is being diverted by the amount of attention and the amount of time that senior leaders are giving to this issue. Let me reassure you that there is agreement that sexual assault is a problem in the military. Now, reasonable minds may differ as to what extent it's a problem, but there is common understanding within the military that this is an issue that we need to deal with. Now, a lot of the attention from Congress, from media, from advocacy groups has focused on the role of military justice, and the role of military justice has played in dealing with or failing to deal with the problem of sexual assault in the military. Is the system antiquated? Does it treat victims fairly? Is it too lenient in its findings or sentencing? Should commanders play such a central role in our process? These are all legitimate questions and questions that society is asking, and rightly so. Congress recently, despite the fact that Professor Cover mentioned, did not pass a call to take commanders out of the process. They have instituted sweeping changes in the military justice system. In fact, I think it's fair to say that in the last 6 months, we've seen changes to the military justice system that are unprecedented, at least since the period directly after World War II. And there are still calls for more fundamental reforms. Now, all this is taking place, at least in my opinion, against a backdrop of too little education and too little understanding about what the military justice system is and why it is the way it is. If the military justice system is to be remade to look more like its civilian counterparts, Well, we should understand the answers to some very basic questions, such as, what is the military justice system? How is it similar to or different from our civilian counterparts? Why is the military justice system separate, and why is it different? How are victims treated in our system, and what rights do they have? How does the military prosecute sexual assault? What kinds of cases do we prosecute? What laws do we prosecute them under? And what sentences can be and are imposed? And finally, what has changed already in our system, and how are those changes working? I'll share my perspectives on these questions, but my primary goal today is to stimulate you to think through these issues for yourselves, to read, to ask questions, to participate in the public debate. I was gratified to see that there are some great readings that have been suggested to you for this talk today, and I'll have a few suggestions later on in my speech as well. But this is too important an issue for you to just sit on the sidelines. Our national security is at stake, not to mention the lives and the freedoms of men and women who wear the uniform of our armed services. So my first question, what is military justice? If you were to go watch a court-martial, and by the way, they're open to the public. I know at least in the Air Force, we have a publicly available website that lists all our upcoming docket. So you can go search by base or search by type of case or whatever, and you can see what kind of cases are coming up, and you can go watch those. And I encourage you to do that. But if you were to watch a court-martial, you would see a lot that's familiar to you. There's a judge. There's a prosecutor, who we call a trial counsel. There's a defense counsel, sometimes more than one. There are motions. In fact, we have extensive motion practice in our courts-martial. Jury, there's a jury, or at least where the defendant elects one. We call them court members. There's presentation of evidence. There's advocacy on both sides. In fact, in my opinion, it's tremendous advocacy on both sides. We are very selective about who we bring into the JAG Corps. Right now, our acceptance rates are running around 4%. So we're really able to take some tremendous advocates and throw them into the courtroom with some great training, some great supervision. Our rules we have the same presumption of innocence, the same standard of proof beyond a reasonable doubt. Our rules of criminal procedure and the rules of evidence are very similar to the federal rules or rules that you might be familiar with. So in many ways, it looks like its civilian counterparts, but in less visible ways, the system is quite different. And that reflects the underlying concern about the military justice system operating as a tool for ensuring good order and discipline in the armed forces. Now, unlike civilian criminal courts, we do not fall or not organized under Article 3 of the Constitution. We're not members of the judicial branch. We fall under Article 1. We're a creature of statute by Congress. And so as a result of the statutory background behind our courts, we don't have a district attorney who makes charging decisions. Those decisions are made by a convening authority, because by act of Congress, courts-martial, being Article 1 bodies, are not standing bodies. There is not a court-martial that sits at Andrews Air Force Base waiting to hear whatever cases might be brought before it. The convening authority, a senior military commander, advised by a senior military lawyer, makes a decision in each particular case to convene a new court-martial to hear those facts. You'll see some familiar charges in our system: murder, larceny, sexual assault. But you'll see many that are unique to our system: fraudulent enlistment, desertion, contempt toward officials, disrespect towards superior commissioned officers, plus the catch-all categories of conduct unbecoming an officer and a gentleman, and conduct that falls under what we call a general article. Any sort of action that is discrediting to the service or that is prejudicial to good order and discipline is a crime under our system. And of course, all those have no counterparts in the civilian world. You also see countless protections that are built into our system, which I'll talk about, that go beyond those of the civilian community. And if you have never had exposure to the military justice system, that might seem a little counterintuitive. The military justice system throughout much of my career has had a reputation, rightly or wrongly, as being less protective of defendants' rights in civilian communities. And I'm here to tell you, as I'll outline later, that's simply not true. Well, why is the military justice system separate and different? I can't talk about the answer to this question without talking about history, because as much as we're a product of the creation of the acts of Congress, we're even more the product of history. Before World War I, the process was very commander-centric. A court-martial was really a court in name only. It was an action strictly within the province of the commander, who often could and did sit as judge and jury in the case. And the reason for that, and this is an important point to understand, the reason for that is the commander's responsibility to ensure good order and discipline in his or her unit. If you're trying to understand why the military justice system is different from what exists in the civilian community, that's the most important point to understand, is because it is a tool for the commander to use to ensure good order and discipline. What do I mean by that? Well, we ask our people in the military to do two very unnatural things: to kill and to be killed, or risk being killed anyways. Neither of those, I would hope, come naturally to a person. And so we have to instill discipline to a degree often unimaginable in the civilian world within our people, to get them to do that, and to do that when being asked without questioning, within limits, as long as it's a lawful order to do so. George Washington understood this. Speaking to his captains of the Virginia regiments in 1756 at the conclusion of the French and Indian War, he told them the following: "Discipline is the soul of an army. It makes small numbers formidable, procures success to the weak, and esteem to all." In short, discipline is essential to any military because of the nature of our mission. And the commanders have historically had a great deal of power in that process, because it is, after all, them who are charged with safeguarding the lives of our men and women and achieving success in our mission. It's a responsibility, having worked with many commanders, that I don't think a lot of people can understand unless they've been there or been close to it. Now, after World War I, there were some efforts at reform. Some procedural requirements were put in place to safeguard rights of defendants. There were some review bodies that were put in place, sort of administrative review bodies of court-martial convictions. But it really wasn't until World War II where the process changed. World War II, of course, we had a mobilization of our country on a scale that was unprecedented in our history. And when we did that, people were exposed to the military justice system in a way that they had not been before. We had more than 2 million courts-martial take place during World War II. And when Johnny came marching home, he came marching home with reports that weren't so flattering about the military justice process. There were reports of hasty proceedings, insufficiently trained lawyers, if there were lawyers at all in a proceeding, dicey convictions, severe sentences. But by far, the biggest complaint, the complaint that Congress was most concerned about, was commanders having undue influence over the process. There were reports of court members, the jury members, being reprimanded because they didn't issue a harsh enough sentence in a particular case, or reprimanding the law officer, the person, the non-judge who sat over a proceeding, or even defense counsel, their careers being impacted because they represented their clients too zealously. Congress was very interested in these reports. They held hearings. They appointed a committee to propose changes to the UCMJ and to draft, for the first time, a uniform code of military justice, because before this, the Army and the Navy had separate military justice systems. Congress did this in a way that I think is a model for how the reform efforts should be going on today. They did extensive fact-finding. It was very open to the public. They did it in a very nonpartisan or bipartisan way, and they were able to reach widespread agreement on what needed to happen to make the UCMJ more fair. The efforts of Congress after World War II were a clear attempt. They say over and over again in the documents, the legislative history, which is all available online. You Google military justice, Library of Congress, you're going to come up with thousands and thousands of pages that are all very readable about the hearings that took place, the notes of the drafting committee and everything. And I think if you're going to participate in this debate, to have some knowledge of what took place after World War II is absolutely critical. But their intent clearly was to balance the needs of discipline and of justice, to preserve the role of the commander in the process, because after all, it's the commander's responsibility to carry out the mission, but to also create a system that was just, both in reality and in appearance. Their reforms included a specific statutory prohibition against what they called unlawful command influence, against the commander having too much of a role in the process, against the commander doing things like reprimanding court members or reprimanding defense counsel or something like that. They provided for military judges and trained defense counsel. They created a separate JAG stovepipe with a requirement for commanders to consult with their staff judge advocates in all courts-martial actions. And they created courts like mine, the one I sit on. Each service has a court of criminal appeals now, thanks to the reforms that took place after World War II. We are courts that have unprecedented powers. We can review a conviction and say, yeah, there's no legal error, everything was done correctly, but we are personally not convinced of the accused's guilt beyond a reasonable doubt, and therefore we decline to approve the conviction. Fact-finding power is unprecedented in an Article III appellate court. We can also say that, yes, the conviction was appropriate, it was factually sufficient, but the sentence in our collective experience was too harsh. And so instead of a, let's say, dishonorable discharge and 2 years confinement, we're only going to affirm a bad conduct discharge and 6 months confinement or something like that. And there are no legal standards per se by which we do that. It's simply a matter of our experience and our judgment as to what should be approved in a given case. So that was a key provision that Congress put in place to ensure that those needs of discipline and justice were being appropriately balanced. And despite regular studies, commissions, updates, critiques, that's still basically the same system that we have today, or at least it was up until about 6 months ago. It was a system aimed at striking a balance between discipline and justice. And it was particularly concerned with ensuring that the public retains confidence in the fairness of the process. So why is our system separate, though? Why not simply send our cases downtown to be prosecuted? Well, one is, of course, the concern for good order and discipline that I mentioned. The second is we operate worldwide. We need one system that applies equally in Indiana as Istanbul, or Alaska and Afghanistan, that takes into account some of these unique military offenses that I talked about before, and that provides some consistency that our service members know what standards they're to be held to no matter where they are. So my next question is, what rights do accused service members have in our system and why? As I mentioned, they have a great deal of protection in our system. Largely because of Congress's action after World War II, our accused service members have far greater protections than their civilian counterparts. For example, Article 31 of the UCMJ provides much greater protection than Miranda rights do. It applies in more situations than Miranda does. Our investigators have to inform suspected service members of more information, more rights that they have than the Miranda rights require. And oh, by the way, Article 31 was in effect more than a dozen years before the Supreme Court decided the Miranda case. We provide free, quality legal representation to accused service members without a need to demonstrate indigency. Our pretrial investigation, at least up until a few months ago, was much more thorough and adversarial and open than a civilian grand jury proceeding. The right to petition a convening authority for clemency. Service members have historically had the right, after a conviction, to petition the commander who convened the court for clemency, for relief. And the commander can grant relief for any reason or no reason at all, at least again up until a few months ago. The commander could overturn the conviction. The commander could disapprove the sentence or reduce it to a lower sentence. And of course, you have courts like mine with unparalleled authority to grant relief. All these rights ensure public trust that America's sons and daughters would be fairly treated when they join the military. F. Lee Bailey said himself that if he was accused of a crime, he would want to be tried in our system over any other. But why so many protections? And do those protections should they still be in place today? Well, one is because Congress put them there. I mean, Congress had hearings, Congress heard from various interest groups, and Congress set up the system that we have. But I think a second reason tied into this is there's an inherent concern about coercion in a rank, hierarchical structure like the military. Why do we need to have greater protections under Article 31 of the UCMJ than under Miranda? Well, it's because we don't want accused service members to feel like they have to waive their rights and speak with investigators unless they've been specifically advised that they don't have to do that. And of course, constitutional concerns come into play as well. Generally speaking, military members enjoy similar but not identical constitutional protections as civilians. The Supreme Court has said that the protections of the Bill of Rights do apply to military members, but given our unique structure and our unique mission, they just apply in a slightly different way than they do to civilians. So our system and the rights that are built into that reflect sort of a trade-off. If military members are to give up some of their constitutional rights by putting on the uniform, we want to make sure that there are other procedural safeguards built into place to make sure that our convictions are just. So how are victims treated in our system? Specifically sexual assault victims. Generally speaking, the process that the victims go through is fairly similar to a civilian system. If a service member or a civilian makes a report of sexual assault, and if they choose to go forward and make that a public report, because we've built in protections where somebody who wants to receive counseling or other services can make a report, but if they don't want that case to be prosecuted, they don't want their name to be put out there, and they don't want to testify in the public trial, they can do that. But if they do decide to make what we call an unrestricted report, they can do so. They'll be interviewed by law enforcement. They'll be interviewed by prosecutors and defense counsel. They'll testify at trial. We have a rape shield law, which is virtually identical to the rape shield law you see in civilian systems. We'd have similar protections under the federal rules of evidence. If there is a problem in the way we treat alleged victims of sexual assault, Jeremy Webber's opinion, then this problem is not unique to the military, because our system is very similar to the system that you would see elsewhere. And my personal experience is, while maybe it always hasn't been this way, investigators, prosecutors, defense counsel, judges, and commanders are very sensitive to the rights of victims, to not have their privacy invaded when it's not warranted, to make sure that they're treated with respect when they're interviewed and when they testify. And now we have a program called Special Victims Counsel, which the Air Force, I'm proud to say, was the first one to step out and provide, where every alleged victim of sexual assault gets their own attorney, a uniformed attorney whose sole job it is, their full-time job, is to represent victims of sexual assault, to make sure they understand the process, to make sure they understand what their rights are, and when necessary, to advocate for their interests in court. For example, if there is a report of prior sexual history of the victim, and the defense is trying to introduce that, the person's Special Victims Counsel can actually argue their position in court as to why that evidence should not come in. We also have a long-standing victim witness advocate program where somebody in the legal office will be there throughout the process to inform the victim of any updates and when's the trial date or what's the next step that you can imagine, or even post-trial is if the person is scheduled to be released from confinement, to make sure that those notifications are made. The one area where our system does differ significantly is in what we call Article 32. That's our pretrial investigation. I mentioned that historically we have had a much more open, much more robust system at the pretrial investigation phase as compared to grand jury proceedings. And that has been a concern for many people, such that Congress has recently enacted changes to the UCMJ to scale back that process. The concern was that victims of sexual assault were basically being forced to go through a fully litigated trial twice, once pre-trial, once at trial. Because our system, our Article 32 process was so robust, defense counsel were basically, doing a full cross-examination before there even was a trial. And I think rightly so, there was a concern about how vigorous should that process be, and Congress saw fit to make some changes to that, to scale that back greatly. Now, of course, the countervailing concern is the rights of the accused. And we want to make sure, even though an accused has his or her day in court and will be represented by counsel, that there are still procedural safeguards to make sure that if the case just isn't factually supported, that the person doesn't have to go to trial without some sort of review beforehand to make sure that there is evidence to at least warrant going forward to a trial. So that's a balance that we're struggling to try and achieve right now. All right. It's taken 35 minutes to reach this point, but the key question is, how does this translate to sexual assault? How do we prosecute sexual assault? What kind of cases do we prosecute? What laws do we prosecute them under? And what sentences are imposed? I could spend another hour talking about Article 120 of the UCMJ, which provides the substantive criminal law for most sexual assault in the military. The brief history is, we used to basically have a fairly concise law. It was basically, if you did something in terms of sexual misconduct, you either got prosecuted for rape or for an indecent assault. For rape, the prosecution had to prove that the act was committed by force and without consent, and it had to basically involve some form of non-consensual intercourse. It did work fairly well. But Congress saw a problem, and I can understand why, because first of all, it didn't cover every instance, but more importantly, there were cases, date rape or acquaintance rape, where jury members, court members, might be reluctant to slap the rape label on an accused service member because their traditional notions of rape involve something quite different. It might be an instance where there was consensual behavior before and after, the alleged sexual assault. And maybe you had court members who just didn't want to call that a rape, even though technically under the law that could be considered a rape. Congress made sweeping changes to Article 120. They set forth over a dozen different kinds of sexual assault categories. They did so fairly quickly, and in my opinion, I think widespread opinion, without a whole lot of coordination. And what we ended up with in 2007 was a law, a new Article 120, which was very difficult to apply. The definitions of crimes were very difficult to apply to given fact scenarios. Just trying to read and understand how these different provisions fit together and which one should be charged in a given factual scenario was very difficult. And it had a particularly unfortunate situation where for a good number of the offenses, it actually required the defense to disprove an element of the offense, at least the way the statute was interpreted by the appellate courts, and that was a constitutional issue. So a good portion of the law was deemed unconstitutional, at least as it could be applied. So Congress went back to the drawing board, and in 2012 adopted a sort of middle ground proposition in Article 120. Which took out some of the concerns that were in the 2007 version. I say all this to say that to the extent that problems in prosecuting sexual assault within that 2007 to 2012 timeframe might shape some of the perception about what the military justice system does and how well we do with regard to sexual assault. Be advised that there are some real reasons why that might be, and we really struggled to put that law into practice. The new law we're just seeing now put into practice because that only applies to acts that took place in the latter half of 2012 and beyond. So we're seeing now convictions and courts-martial that take place under that law, and the first appellate cases are just starting to reach my level on that. So we'll see how that plays out. Under this most recent version of Article 120, it is very expansive, in fact, much more expansive than most civilian criminal codes. Somebody can be prosecuted for sexual assault for non-consensual kissing, for touching any part of the body as long as it has the requisite intent. Even potentially touching somebody on the shoulder as long as you have that intent. Somebody could be prosecuted under Article 120 and have all the collateral consequences that come with that, such as not only a court-martial conviction, but registered sex offender status. In my experience, and not just in my experience, but according to the best data that we've been able to gather in response to congressional inquiries, there are a number of times, dozens of cases, where a civilian district attorney for a crime that committed off base by a service member declined to prosecute. But we decided to go forward and actually obtained a conviction. I was the staff judge advocate at Vandenberg Air Force Base in California before my current assignment, and we had such a case. A service member reported to the civilian police that she had been sexually assaulted by another service member off base. The local police investigated. Within a couple days, decided that they did not want to prosecute this case. We asked for jurisdiction. We got jurisdiction. We investigated it more thoroughly. We found a second alleged victim by the same service member. We got a conviction, at least with regards to one of the service members. And this case did make national headlines because this was a case where the commander decided to, in the clemency process, overturn the conviction as part of her authority or statutory authority that she had under the UCMJ. Even though the end result on that was that the service member was not convicted, I think that's a good example from a mindset perspective and from a perspective of the quality of our counsel and the determination of our investigators and our military attorneys and our commanders. It's an example about how we really do take this seriously, and we are willing to prosecute cases that that the civilian district attorneys might consider unwinnable or weak. It is not at all uncommon. Well, we will prosecute a case, for example, where intercourse began consensually but was withdrawn during the act, where the alleged victim had some sort of consensual behavior with the accused before and maybe even immediately after the alleged sexual assault. These are difficult cases, obviously. They're difficult cases at trial. They're difficult cases on appeal. But they're cases that we feel it's important to bring to trial. Sentencing. Sentencing is wide open in the military. We do not have mandatory minimums. The reason for that is essentially is we trust our court members, who are educated, experienced service members, to fashion a sentence which meets the needs of justice and good order and discipline in a given case. We recognize that no two cases are identical, that no two service members are identical, that everybody may have different rehabilitative potential. There might be different victim impact in one case versus another. And because of the difficulties in trying to craft some sort of sentencing guidelines in those cases, by and large, we have no mandatory minimums for our sentencing. That has changed recently with regard to sexual assault as well, as Congress has imposed that anybody convicted under Article 120 of the UCMJ now must receive a dishonorable discharge, which is the most severe kind of punitive discharge a person can receive at trial. It's not simply a matter of firing the person from the military. It's a matter of branding them for life, the quality of their military service. We've seen recently a number of amendments to the UCMJ. I mentioned that the pretrial investigation has been scaled back. We've formally incorporated a Bill of Rights for victims. We've provided further review of commanders' decisions not to prosecute given cases. We have now a DoD-wide Special Victims Counsel program so that all alleged victims of sexual assault have their own attorney represent them, as long as they're eligible for that. Mandatory dishonorable discharge or dismissal for those convicted of sexual assault, and the convening authority, the commander's ability to overturn a conviction in cases, has now been withdrawn under recent amendments to the UCMJ. Except in very narrow situations where basically if a person is charged with, let's say, sexual assault and adultery. Adultery is an offense under the UCMJ. Standing by itself, it might not normally warrant a court-martial conviction. It might be handled at a lower level. If the person is acquitted of sexual assault but convicted of adultery, the commander still retains some authority to disapprove that adultery conviction, out of the sense that had it not been for the sexual assault charge that went with that, this probably would not have been a court-martial. Again, that's still being worked out as to how that's going to be implemented. I think it's too early to tell if these changes are working, honestly. We've seen reports of increased reports of sexual assault in the last 2 years, which some could look at and say that's a sign that things are getting worse. Some could look at and say that's a sign that victims are more comfortable in coming forward and reporting sexual assault because of the protections we've built in for them. I do know that we have high satisfaction with the Special Victims Counsel program. Victims overwhelmingly like this program. They feel empowered by it, they feel informed by it, and they are much more likely to see a case through to trial rather than try to back out of the process out of frustration or for whatever reason. Despite all the significant changes made to the system in recent months, there are loud and powerful voices calling for even more change. Remove the commander from the process. Remove all sexual assault cases from the military justice process altogether, are some of the proposals. There have even been more radical calls, including a prominent legislator's proposal to allow victims to appeal a not guilty finding. I leave it to your judgment as to whether that passes constitutional muster. I will say all this takes place in an environment of very intense political scrutiny. And I mentioned that after World War II, one of the concerns, the main concern that Congress had, was unlawful command influence. Because we're hierarchical, We do not want superior commanders to unlawfully insert themselves in a court-martial process. And we are seeing now motions and rulings by military judges where that is being made an issue. Maybe it's comments by the commander-in-chief, or maybe it's comments by people who aren't in the military but have a very high degree of authority over military careers, such as congressional members. We've seen careers of commanders who have taken actions in sexual assault cases be impacted, be held up by individual senators out of concern that they didn't take the right action in a given case. Does that create an environment, an unlawful command influence type of environment? Does that affect the service member's right to a fair trial? These are issues that my court is wrestling with right now. These aren't just issues for me, though. These are issues for us all. If we are to really support the troops, then we need to make sure that everyone, victim, accused, witness, has a fair system, and that the system actually contributes to an effective fighting force. I would ask you to ask yourself certain questions. Why remove sexual assault cases from the authority of the commanders? What specific problem is that aimed at, other than a general feeling that there's some inherent conflict of interest in such situations? Is there any evidence or indication that military lawyers would be any better at handling such cases? What does the data show about sexual assault, the sexual assault crisis in the military, and whether the military justice system is unable to handle this crisis? I would recommend to your review an article by Major Matt Burris. It just came out. Actually, it's forthcoming, but it's available online. It's called Thinking Slow About Sexual Assault in the Military. And it's in an upcoming issue of the Buffalo Journal of Gender Law and Social Policy. There's also a 2013 EEOC, Equal Employment Opportunity Commission, study on the extent of sexual assault in the military, and to what extent is this a problem in the military when you compare it to other similar sorts of demographic populations, like college campuses. How fast should the reform be implemented? Have the previous reform efforts had time to take hold? Ultimately, is sexual assault in the military an institutional crisis? Or is it just a symptom of a broader societal problem? And what is the end state that we hope to achieve? Is it 0 sexual assaults? Is it simply a number that's lower than civilian population? How much lower? And what would it take to achieve that? Is it worth us imposing a military where we have separate training facilities for men and women? Is it worth a military where alcohol is prohibited altogether? Is it worth a military where the freedoms of our military members, who are young people, need to be curtailed in order to achieve this end state that we hope to achieve? All right. I've used up almost all of our time. I do apologize. I thank you for your time and attention. I assure you we do have the same goal, which is to study this issue with an open mind and without hopefully any preconceived bias, and ultimately to reach a society where all our military members feel free to operate, to live without fear of being sexually assaulted, and that if they are accused of that they have a system that they trust will judge them fairly. So with that, if we have time for a question or two, I'd be happy to take that.
Let's see, we have a number of questions. Yeah, we have about 10 minutes left, so we'll make sure to get some questions in. Can you come up or use one of the mics just so we can get you? We can hear you.
Thank you. It was a wonderful presentation. Approximately half of my practice is the defense of military individuals charged with crimes. I've only been doing so for about the last 3 years, but for 45 years I've been defending people charged with crimes. I realize that you really have told us that the numbers are up, that we have to worry about Article 37 situations, but I'm seeing more and more often than not them forcing people to Article 15 hearings 5-6 days after being charged, then threatened if you don't just waive all your Booker rights, you're going to end up being convicted of 120, which still is 120, and you're going to register for the rest of your life. I have one right now where he couldn't even get to defense counsel. It's out in Denver. And he was charged on the 27th of March, and the Article 15 was on the 1st of April. And I must tell you that in talking to, I'm part of now of a law firm that does this, in talking to so many, it is common conjecture in the military that the pendulum, as often happens in the military, has swung far too wide another way. And that, I mean, who can forget, if they saw it, that hearing that Senator Gillibrand and certainly Senator McCaskill had, where they just laced and embarrassed the head lawyer for every service. And you know, I realize from your position it may be an unfair, and if it is, I'll understand if you want to speak in private. But this is from an old timer with 600 jury trials.
Yes, sir.
Thank you
for the question. And just so everyone's clear, what he's speaking about is in terms of Article 15. There are procedures that commanders have below the level of a court-martial to deal with more minor offenses. One of those is an Article 15 non-judicial punishment proceeding where the commander essentially acts as judge and jury in the case. His or her punishment options are limited, generally involving forfeitures of pay, reduction in rank, things like that. And it can impact the member's career as well. So your question, sir, was essentially, specifically about Article 15 being basically forced upon a member. Normally a service member has the right to turn down an Article 15 proceeding and then risk that proceeding might be taken to a court-martial and might be convicted. And you know, they're seeing cases where you know, the person's being given a very quick Article 15, being told, make the decision right now, and if you turn it down, then we're going to take you to a court-martial, and you may be convicted and may be registered as a sex offender and things like that. I will say, my experience in the Air Force, right now, most sexual assault offenses, if it's anything near Article 120, typically does not get taken to an Article 15. We will typically immediately take that to court-martial, which maybe doesn't address the concern that you raised.
My current case is maybe.
Okay. I will say, just generally speaking, I'd be happy to talk with you more offline. I do see the debate starting to shift a little bit, that the defense community particularly leading the charge on some of this. And I am starting to see articles, in some publications like the Washington Times, but some in more widespread publications, talking about the concern of unlawful command influence, talking about the concern of our service members getting a fair trial here. And so I'm encouraged by that. We're also seeing rulings by trial judges where they are finding unlawful command influence in certain cases, and those are making the news as well. President Obama made a statement in result to after one particular act that got a lot of attention by military judges, and it resulted in a few findings of unlawful command influence as well. Doesn't exactly address you, but I'd be happy to talk with you more.
I have an Article 15, and I'm alleging Article 37 violation.
Understood. All right, thank you.
All right. Could you just tell me again who authored Thinking Slow About Sexual Assault in the Military, where we find that, please?
Yes, Major Matt Burris. And I haven't talked to him, so I'm totally, you know,
Could you spell the last name?
Burris. I know Matt, he's a good thinker. I read his article. I recommend it to you. And it's not published yet, but it is available if you do a web search for his name and the title of the article. thinking slow. Just thinking slow about sexual assault. I think
You said something about Buffalo something.
it's the Buffalo Journal of Gender Law and Social Policy.
There's a big difference in Congress today and Congress after World War II. Don't we have, I think there's only, what, 5 members of Congress, if even that now? Senator McCain, one of them, who are in the military. What does that portend for the changes they want to make?
That's why education is so critical here. We need to make sure, fundamental principle of our Constitution is civilian control of the military. And so absolutely, we are bound by Congress's enactments, and we are a creature of Congress. But we need to make sure that those decisions, particularly in light of the concern that you raise, are educated ones, and that Congress understands why the system is different, and that particularly they understand this need for good order and discipline. There's a strong argument to be made that we do everything in the military through commanders. Commanders have broad responsibility, and they ought to have broad authority to go with that responsibility. They're to carry out the mission, whatever that mission may be, whether that's to win a war or whether that's to ensure that, that we deal with this sexual assault issue.
Thank you.
I have several family members, both men and women, who serve in pretty much every branch of the military. So obviously sexual assault for my female family members has been a concern for me. Do you have any statistics on how many of these sexual assault cases end in clemency?
I know enough to say it is very rare. We had a congressional inquiry about this subject. In terms of cases that have actually been overturned in clemency, the 2 or 3 cases that you've heard about really comprise the bulk of those cases. I don't know the number exactly. I feel fairly comfortable saying it's fewer than 10 over the past several years. I will say as well, in that same inquiry, the services were asked, how often does a commander proceed to trial when the staff judge advocate, the lawyer, recommends against that? Because the concern in some of these cases was that the lawyer was recommending upholding the conviction, the commander went against the lawyer's advice. What about the flip side of that? And that is a much more common occurrence where the staff judge advocate will say, we don't think the evidence is here. In my legal opinion, I do not recommend taking this case to trial. And we've seen much more frequently commanders take those cases to trial.
Colonel, I was wondering if you could speak to those instances where a case arises out of a situation where the victim's conduct may have also amounted to some sort of misconduct that is a violation?
That was out of this whole spotlight on sexual assault in the military. One of the very beneficial things is we really did learn that there were a number of victims of sexual assault who did not want to come forward and report that because they were concerned about their own misconduct. Maybe underage drinking, maybe adultery, or whatever other sort of related misconduct was wrapped up in the facts behind the alleged sexual assault. A couple years ago, the military on its own instituted a policy that, and I believe Congress may have subsequently ratified that, although I'm not certain on that. But basically, right now, there has to be a very high-level review if the military is to discipline an alleged victim of sexual assault for any alleged misconduct arising out of that same incident. So, it gives alleged victims some more peace of mind that, they're not going to be immediately retaliated against without some very high-level review to make sure that that is warranted in that particular case.
Unfortunately, we have used up the balance of our time. Please join me in thanking Lieutenant Colonel Webb. Well,
very much. I'll be around afterward if you have
That's right, please
individual
feel free.
questions.
And there is a showing of the film Dictator in the dock, which is about a prosecution of.
Oh, I'm not in charge of
Okay,
it, but.
former Guatemalan president for crimes against humanity, that's showing tomorrow night at 6 p.m.